Hi, everybody. It's Jim Ostrowski back with the Liberty Moving podcast. Something a little different today. And one of the questions that people want to know about podcasts, I think the number one question, why should I watch yours when there's like 5,000 podcasts out there? So, as I've said before, I don't discourage you from watching other podcasts. I watch a lot of podcasts myself, there's a lot of good ones. But today I'm going to be talking about a case that I'm filing in the U.S. Supreme Court next week about an issue that I wrote about 27 years ago, predicting the Heller decision that establishes the individual right to bear arms. And I'm also going to be talking about a book I wrote about the Second Amendment. The Second Amendment works. So I've got a foot in all the different things going on. Still a practicing lawyer, although I'm slowing down my law practice to do more political work. I'm a writer. Can I say I'm a scholar? I don't know. I've written like 7 books and 300 articles, several peer review articles, taught constitutional law at the college level for 1 semester anyway, till they found out I was an anti-federalist. So I guess that's why you should watch the podcast, because I'm the only person who's podcasting who's going to the Supreme Court this week on the Second Amendment, who's written a book about the Second Amendment. So if you're a gun guy, I'm your guy, because nobody else has done that. So I just want to talk real quick. So I wrote like an article for the Mises Institute in 1994, and they said the Second Amendment protects the right of the citizen to arm himself against government tyranny. Now, the prevailing view in the legal profession was that the Second Amendment was a dead letter. It has something to do with the militia and nothing else. I also wrote other articles much later on explicitly saying that the Second Amendment protects an individual right to bear arms. So in 2008, the Heller decision came out, and I tried to get a group of people together to file a lawsuit against the New York pistol permit law, which is one of the oldest and one of the worst in the country, the Sullivan Act. And it kind of fell apart because it was another case downstate, the Kalkalski case, which I guess I'll mention in a second. And I tried to convince them, just because somebody else is filing a lawsuit doesn't mean you should. But they didn't want to spend their own money. Other people did. That's fine. I don't argue with clients. I never had an argument with a client over money in like 37 years. So I let that sit. I went on. I was doing other things. And when the SAFE Act came along, the New York SAFE Act, there was a lot of activity, and I wasn't really doing anything involving the SAFE Act. So I said, well, maybe we can get this pistol permit thing going again. And I looked up that Kalkalski case, which lost in the Second Circuit. And I found out, well, they're only raising the one issue of the proper cause to carry. And I said, darn, I really should have gotten that thing going years ago. So I got the gang together again with the help of the Erie County Libertarian Party, some friends of mine, some contacts of mine. We filed a lawsuit in 2015, Libertarian Party v. Andrew M. Cuomo and Eric Schneiderman, who's now out of office, replaced by the far-left Attorney General down in New York City, Letitia James. So long story short, I'm not going to go through the whole procedural history. We raised the government. What the difference between this case and all the other cases, and there's the caption, is that we raised the government tyranny argument. A lot of the big firms hired by the big gun groups are basically afraid to raise this argument. In fact, we had a law firm that wanted to help out. They said, well, we don't want to raise the government tyranny argument. Well, my view basically is that if we keep the Second Amendment litigation narrow, legalistic, and boring, we're going to win these very narrow victories that don't add up to anything. You're going to have a right to have a pea shooter in your house. Now, when you factor in the reality is that we're probably going to have a Democrat in the White House for 8 years. We don't know that, but you would bet on that if you were in Vegas, so there'd be another term of a Democrat. If you don't understand that, then you're dreaming and you don't understand what's going on in the country. But this isn't a podcast about the political scene. We now have 5 pro-Second Amendment, reliable pro-Second Amendment votes. If we get one more Democrat, that's going to be 4, and we're going to go back to the bad old days when there was no Supreme Court gun cases after McDonald. So this is the time to strike. We lost in the district court. We lost in the Second Circuit, which we expected to, frankly. And now we're going to the Supreme Court. And this brief will be filed probably late this week, maybe Monday at the latest or Tuesday. So I don't raise money for political purposes, but these crowdfunding public interest lawsuits, there's no other way to do it. And by the way, I have done very few of these. I did the pork lawsuit, which was about corporate welfare. We got 50 people together. They threw in $100. I've done this case. I'm doing a lockdown case. Frankly, I don't think we're even fundraising on that. It was really paid for by the plaintiff. So I don't come to people like all the time saying, hey, there's a crowdfunding. It's 2 or 3. I think the SAFE Act case where I represented Ben Wassel, I think we did some crowdfunding on that. It just occurred to me. So really very few times do I come to people. We're doing it on a shoestring. Everything I do on a shoestring, because there's no sugar daddy. There's no man behind the curtain. There's no, Koch brothers or anything of that nature. I do the printing myself, which is a big hassle, but it saves a couple of $3,000. That money can then go into paying the very small attorney's fees. So there's a filing fee. There's still some printing costs. Even if I do it in-house, I still have to I'm not a printer. So basically, we have a fundraising goal of $5,000. We've raised $700. I'm probably not going to raise the $5,000, but if we could get a couple more bucks in, that's what keeps me going. My books, my activism, it's all really funded by my law practice and my book sales. That's my first book, about which more in a second. So if you want to contribute a small donation, go to Steve Filano's site. Steve's the best young Second Amendment activist. He's already running the best New York State gun rights organization, 2anys.com. Look for the Supreme Court case, and you can make a small donation through him. So basically, I'm just going to go through real quick. I don't want to keep you too long today. Read a couple of excerpts from the brief so you can see what you would be supporting. And even if you're not going to support it, you should understand what we're doing here. So, just to start out, I like to be real. When people who know me know Al Pacino's speech, greatest speech of all time at any given Sunday. Why? One of the reasons is he keeps it real. So I like to keep it real in my legal. I don't like, one of my mottos is legal writing doesn't have to be boring. I can't stand reading boring legal briefs, so I don't write them myself or try not to. So I like to keep it real. I like to tell the court, let's be honest here, judges. Let's get real. No bullshit. So I start out the case. This lawsuit is a true grassroots shoestring effort to challenge the New York pistol permit law, which so glaringly violates the right to bear arms as enunciated by this court in Heller and McDonald. We asked each plaintiff to ante up $200 to get the case rolling. We are not affiliated and receive no funding from any national gun rights organization. The plaintiff's lawyer, me, is in the courts below as a public interest lawyer works out of his house. The case has been funded by small donations throughout. We are opposed by 3 gigantic and well-funded law firms, the New York Attorney General and 2 amicus curiae. Everytown for Gun Safety, that would be Michael Bloomberg, billionaire, and Giffords Law Center, which is also funded by 1 or more billionaires. We filed a comprehensive challenge. The main point I want to make here is that we challenged the court to say, is the purpose of the Second Amendment to deter government tyranny? Because that is the purpose. And if that's not its purpose, what's its purpose? And who cares, frankly? Who cares? It's not about shooting burglars. That's bullshit. Total bullshit. So guess what? The district court ignored that argument. It's in the pleadings extensively, in great detail. It's not just mentioned. It's featured in the complaint, which is how you start the lawsuit, filing a complaint. District court ignored it. The other attorneys ignored it, except for one very brief mention where they said, "Oh, that's fantastical." And I pointed out, well, that's interesting because Letitia James called Donald Trump a tyrant and said he wants to become a dictator. Well, that's my point. So my point is that if you don't have a well-armed civilian population, the government can lapse into a tyranny. We happen to have one, and that's been a deterrent to tyranny. It's all in the book, The Second Amendment Works. You're too cheap to buy it. It's free on Steve Filano's site, 2anys.com. If you want to get a copy, it's $6. I don't know if you can afford that. Kindle's $4, but it's free. It was the only book of mine that's free online because it's so important. It's more important than me selling a book, because this is game, set, match, people. The right to bear arms is game, set, match. I think if you're listening to my podcast, you probably already agree with me. So why did they ignore the government tyranny argument? Why do people usually ignore an argument? Because they have no answer to it. They literally have no answer. So let's see what else I have. A little factual background here about New York State. Well, New York State has for many years led the nation in violating the right to bear arms and flouting this court's rulings. This arises out of its status as a leading progressive state, as gun control is rooted not in logic or evidence, but in a political ideology, progressivism. This is so important to understand, whose essence is to use aggressive state action as a form of therapy to make people feel better as opposed to solving any actual problems. It therefore tends to generate new and major problems, etc., etc. Now, if you don't understand that gun control is a manifestation of progressive ideology, as explained in my book, Progressivism Primer, you're lost. You're lost. You don't forget about it. So we raise this. We talk about it in the book. We talk about it in the brief, because if you can knock out the ideology of the other side, you can win the argument. If you ignore that ideology, like the big firm lawyers and the big gun groups do, they tend to get their asses kicked, which is basically what happened. Look at the NYSERPA case where the court said it was moot. They're not going to moot my case. In other words, they're not going to say, well, how can we stop Ostrowski's lawsuit? Well, he challenged the whole damn statute. The whole statute. Everything, including the licensing requirement itself. So the only way to get rid of it is by repealing the Sullivan Act. I guess we can't do that. So they're not going to moot this case. So let's see what else we got here. We talk about the intermediate scrutiny standard, a lot of legalese. I won't go into it in detail. The bottom line with the intermediate scrutiny standard is that Judge Breyer kind of talked about that in his dissent in Heller, which lost. But that's the standard that's prevailing in the lower courts, because the lower court judges don't like the Second Amendment. Why? Because they're progressives. If they're progressives, if you don't understand that, again, read the books. They're cheap. How much money have you spent on books and political stuff and donations to candidates that didn't accomplish anything? This is the ideology that's ruling America for 105 years. It's $15, people. Panel's dissent, they adopted Breyer's dissent. So look, all the legal stuff. I've been a lawyer for 37 years. I know all the legalese. I've won basically every type of case I've had. I have a winning percentage, or a percentage that's above what you would expect for that type of case compared to other lawyers. So believe me, I have all the technical mumbo jumbo that the judges need to hear. I add the reality of the Second Amendment is a political issue. If you don't talk about politics or the reality on the ground, you're lost. Read some of these Second Amendment briefs filed by the big firm lawyers. I mean, you're going to need, that energy drink or whatever it's called. I don't use that stuff myself. So I'm going to go another about 5 minutes here. The panel's decision ignores the purpose of the Second Amendment, which is to deter government tyranny. I've already talked about that. So what else do we have? Why is the government tyranny argument important for the legal mumbo jumbo and the legal sort of technical bullshit? Well, look at proper cause. Proper cause, do you have a right to have a gun outside your house? Well, of course you do. It's part of your right to protect the sovereignty of the people. If you have a democracy, that means the people are sovereign. Okay, well, how do the people protect themselves when somebody threatens their sovereignty? Well, you have an election. What if they cancel the election? I asked this in the Second Circuit. The one judge, didn't know what to say. What are you going to say? There's no argument. You can have a protest. What if they start shooting you, like we mentioned in one of our briefs about shooting protesters in Venezuela? You have the right to protect your sovereignty if the people have sovereignty. You have the right to deter government tyranny and fight against government tyranny. How can you do that if you have a handgun in your house? That's ridiculous. You have a right to have a damn rifle, a damn good rifle. That's why if you ignore the government tyranny argument, you get your ass kicked in court, which is, again, what most of the gun groups have gotten. They're getting their asses kicked. They won 2 cases, a couple of small other cases, but basically Heller and McDonald. What have you done for me lately? So also, judges like to have these formulas. They're very pretentious. The balancing test. There's no balancing test mentioned in the Constitution, but this is what they've developed over the years. Someday I'll try to figure out, write a book about the origin of that. It's on my list. But if you're going to have a balancing test or a formula or something, you have to factor in the government tyranny aspect. Because if you don't, it's basically going to get down to what the Bloomberg people and the Gabby Giffords people threw at me in the Second Circuit. All these bullshit studies by biased, progressive researchers. They're about as bad as journalists. They just write maybe a little better and longer and make it look better. Without the government tyranny argument, you're going to lose the cost-benefit analysis because they're going to say, oh, some kid can get a gun, and, that the father didn't lock up or the mother didn't lock up. Without the government tyranny argument, you can never make sense of the Second Amendment, and we won't have any significant right to bear arms other than the right to have a gun in your house if you have permission from a local judge. So it's a losing path. It's a losing path. And I pointed that out in the brief. So that's basically it. Now, this podcast is basically about direct citizen action. You say, wait a second, Ostrowski, you're going to court. That's not direct action. Well, you're right. You're right in a way. But we use these lawsuits. We got an anti-lockdown case going. It's the same thing. We don't just do the legalistic bullshit. We talk about the theory of economics, the theory of political science, the theory of philosophy. The lockdown doesn't work. You guys don't have enough knowledge. We quote Hayek, for God's sake, in our brief, along with Buffalo Springfield's song, There's Something Happening Now, which is, by the way, about a curfew, which is kind of like a lockdown. So we use these briefs, these cases, to educate the public, to get people energized. We put out the book. The book is kind of like, the reason I wrote this book, in part, is I was getting all these studies and I wanted to answer all the arguments. So in the book, there's actually empirical evidence that without the right to bear arms, you have an unstable political system. Why? Because in these banana republics, the generals know, well, let's see, we'll get like 500 Marines to, not our Marines, but their Marines, whatever, special forces. We'll take over the palace. We'll take over the television station. We'll take over the power station, and we'll run the country. Why? Because the people don't have any guns. And the evidence, I'm not going to go through the whole book. The evidence is there. The statistical evidence is there. So Education is a form of direct citizen action. We also talk about there's other forms of direct. First of all, obtaining weapons that you can use to be part of a militia to defend yourself and your neighbors against strange men in strange uniforms coming into your neighborhood. That's direct action too. So it does. This case does integrate well with my philosophy and approach of direct citizen action. So I'm going to leave it at that. We're at about 20 minutes. I don't like to talk everybody's ear off, but again, if you've heard what I had to say today, you know you're not hearing this in any other podcast on the web. Russian, China, English, Canadian, whatever. I'm not saying I have the best podcast. I'm not saying you shouldn't listen to other podcasts. I'm saying you need to listen to my podcast. I got to get to 1,000 subscribers. I noticed that I was a little inactive. I did a pretty hard-hitting podcast the other day about the Twitter thing, and I did add a lot of subscribers. I want to thank those people. If I can get up to 1,000, and I can really go to town. I can do live events. I can start advertising. And again, for political stuff, I don't ask for donations. I'm completely independent. I can't be bought off. There's no man behind the curtain. I've been a libertarian for 42 years. I'm an open book. The book behind me talks about how I became a libertarian. So, you know what you're getting. I often wonder, you see a lot of people, they got really slick websites, and you wonder where they get the money from, and who gave them the money, and what do they owe to those people with the money. I don't owe anybody anything except my parents, who are both deceased. They gave me a great, start in my life, a great private school education. To whom much is given, much is expected. Other than that, I don't owe the political bosses anything. I don't owe the Beltway libertarians anything. They don't give me anything. They don't even promote any of my books. It's insane. Progressive is a Primer has sold 11,000 copies. It's one of the best-selling libertarian books in the last 10 years. None of these people even mentioned it. Reason Magazine, screw them. I sent them a book. They didn't even acknowledge the existence of the book. So I guess I lost favor with them because they once did publish one or two of my book reviews or whatever. So that's about it. Now, I know I'm going a little over time, but I'm going to do a new approach. With the Biden administration, he's just a disaster. I don't know if I want to waste a lot of time analyzing the current events of the day. So what I'm going to do is, I've written 7 books. I wrote each of one of them for a specific reason. It wasn't just, I'm going to write a book today and, get rich. They each cover a certain aspect of libertarian theory and or practice, and they kind of go in a sort of a logical order. So my next podcast, I'm going to start at the beginning, talk about this book, which actually didn't sell that well. It's kind of on-demand publishing. Very tough to get a distributor, but this thing caused a little bit of a revolution in Buffalo before it petered out for reasons I'll get into. Not for lack of effort, I assure you. It caused a big stir in Buffalo, and I learned a lot of lessons in those 2-3 year period, believe me, that were later applied to other books. So I'm going to start talking about, if you need to understand what the political class is. If you don't understand what the political class is, again, how can you even understand politics? It's all about the political class. You got and both parties have a political class too. This is the Republican Party, which I'm huge, non-fan of. They have their own political class. And it's a little different from the Democratic political class, but I understand the difference because I've been in both parties, I've fought both parties, I've litigated against both parties. So I totally understand it. So next podcast, I'm going to start to go through my books, chapter by chapter, and you'll know what I figured out. And if I tell people how long I've been in politics, they kind of don't believe it. But I started really young, and I've been in it for 45 years, done pretty much everything you could possibly imagine in politics, or really anti-politics. So, and in the courts and writing scholarly articles as well. So I'm going to go through the whole thing. You're going to know what I know, basically, except you don't have to spend 45 years learning it. So again, see you soon. Jim Ostrowski for the Liberty Moving podcast at the world headquarters of libertymovement.org, Buffalo, New York.